As per statistics placed before me, the cases filed before this tribunal since inception till 31st of January 2023 are 15,429, out of which the cases disposed of are 10,357. And if I point out the statistics from 14th March 2022, I took charge from 14th March last year, 14th March 2022 till 31st of January 23, the filing is 955 cases and the disposal is 844 cases. This trend is encouraging as disposal rate is catching up with the filing rate of the cases. We are conscious of the desirability of the speedy disposal of the cases in rapidly changing technology to boost the confidence of the stakeholders. I have also constituted one more bench of honorable member to hold separate sittings for speedy hearing and disposal of pending cases. Member judicial is now sitting as a separate court, so my disposal is double now. And he is also a very speedy judge. Issues those which are coming to TDSAT, because civil court has no jurisdiction. Issue and appeal from TDSAT are going directly to Supreme Court by the way of civil appeal. Issues those are raised before TDSAT in various cases pertaining to telecom and broadcasting sector include licensing disputes on AGR, interpretation of license disputes, internet services, IUC, allocation and usage of spectrum, disconnection of signals, audit issues pertaining to technical compliance and commercial compliance under DAS regime, recovery of subscription charges and STBs, placement of channel and carriage of signals, etc. Over the years, this tribunal has evolved by strengthening its justice delivery system. We have established mediation center in the year 2013. The total matters referred at the mediation center are 528, out of which 197 cases have been settled, 12 are pending, and success rate of a mediation center at TDSAT is around 37%. I assure that TDSAT would continue its pursuit for expeditious resolution of disputes. I wish the platform of this seminar would facilitate subject experts and stakeholders to deliberate upon the key areas and share their thoughts and experience in the sector for the benefit of all concerned. I once again welcome you all who is present in this august gathering. Thank you and Jai Hind.
Thank you so very much, sir. Now, I would like to introduce Shri R. Sankar Narayana, sir, Additional Solicitor General of India South. He was enrolled in the Bar Council of Tamil Nadu in the year 1974 and was later designated as a senior counsel. He has practiced extensively in the areas of corporate law, arbitration, and general civil suits. He is well known for conducting the litigation between the Chabaria brothers, which spanned nearly a decade. In July 2020, he was appointed Solicitor General for Madras High Court. In December 2022, he was appointed the Additional Solicitor General of India Southern Zone. He has often acted towards his interest to promote democracy and philanthropy. Sir, please share your words of wisdom and experience with us.
Good morning to all of you. Honorable Justice M.M. Sundaresh, Justice Supreme Court of India. Honorable Justice T. Raja, Acting Chief Justice of the Madras High Court. Honorable Justice Mr. D.N. Patel, Chairman of this Tribunal. Honorable Justice Mr. Gautam, member of the Judicial Member of the Tribunal. Honorable Justice Abdul Kudus, Honorable Justice Saravanan, Honorable Justice Anita Sumant, my friend Mr. Sundaresan, Prabhakaran, Muthukumar, and other dignitaries off and on the dais. Having started my practice purely on civil side and then drifted to the corporate side, this jurisdiction is absolutely new to me. I happened to read the Act only yesterday to find out the broad width and scope of this Act. And the statistics given are really so wonderful, particularly in days when tribunalization is being criticized everywhere. I also participate in such criticism. According to me, many of the tribunals have failed. In such a situation, it is really heartening to note that a particular tribunal has not merely entertained the petitions, but disposed of the same. The normal tendency is whenever a new law is enacted, there is a rush. People go there as if something else is available. They go there and the practice goes up, and ultimately the tribunals do not function in the same manner all the time. But I find that this tribunal is definitely a different category. TDSAT spreads its jurisdictional wing over wide area of disputes ranging from telecom, broadcasting services, cyber matters, and airport, the authority fares, etc. Although tribunalization of judicial functions has had a share of its debates, the setting up of TDSAT in 2000 is a success story which is in favor of those advocating tribunalization. As of 2013, a study has revealed that TDSAT has an efficient disposal of almost 100%. This is what I find from the website and other material. And learned Justice Gautam told me that the first appeals are almost over. And therefore, unless a fresh first appeals comes, there will be no appellate jurisdiction at all at that particular place. But the changing market conditions, which is consequential to the advancement of technology, has invited various crises for the TROI to deal with, thereby increasing the burden on dispute resolution wing. These rapid developments demand the re-examination of the existing regulatory approaches, requiring regulators to move quickly and be constantly prepared for demanding times. Conventionally, arbitration and mediation has been the best compartmentalized for private and commercial disputes, and regulatory adjudication for public policy issues. It is the flexibility in the strict compartmentalization that needs to be reviewed to keep pace with the rapid changes in the telecommunications sector. In line with the same, and in aid efficiency of TDSAT's resolution of disputes 2013, saw the setting up of Mediation Center for the resolution of disputes and another welcome mechanism for pre-litigation mediation in the telecommunication disputes. But having said that the civil court has no jurisdiction, and that wide variety of matters, settlements have taken place, judicial decisions have been rendered, I really do not know how matters are still available for arbitration and mediation. But then the trend is today to encourage the alternative dispute resolution. My friend Mr. Wilson had organized the Joint Parliamentary Committee, had made arrangements where we participated in the mediation bill that is now been tabled in the Parliament, and probably the discussions are going on. If that bill is passed and enactment comes, that is going to take a very strong roots in the system of our judicial delivery system itself. Now, therefore, one has to consider the question of arbitrability. With respect to the arbitrability of the disputes in India has resulted in various judgments clarifying the uncertainty. Section 2(3) of the Arbitration Act provides that certain disputes may not be submitted to arbitration. Section 34(2)(b) and 48(2) of the Act provide for setting aside and refusal to enforce arbitral award if the subject matter of the dispute is not capable of settlement by arbitration under the law. For the sake of convenience, we may refer to the judgment of the Supreme Court in Vidya Tolia and others versus Durga Trading Corporation, which proposes a fourfold test to determine arbitrability. As per the judgment, an issue is not arbitrable if it relates to the actions in rem that do not pertain to the subordinate rights in personam that arise from the rights in rem, affects third-party rights, have erga woman's effect, require centralized adjudication, and mutual adjudication would not be appropriate, relates to inalienable sovereign and public interest functions of the state, is expressly or by necessary implication non-arbitrable under specific statute. Generally, the fact that the subject matter of the dispute relates to telecom will not affect its arbitrability. In few types of telecom disputes, however, arbitrability can come into play due to state control of telecommunications networks and policy consideration at stake, leading the national authorities to reserve particular matters for decision by the tribunals. Therefore, the arbitration is barred in respect of matters which are within the exclusive jurisdiction of TDSAT under the provisions of Troy Act 1997. I am referring to a judgment of the Kerala High Court on this aspect, A. Salim versus Assistant Satellite Communication Limited, 2022. The question on arbitrary of dispute was raised in Viom Network Limited versus S. Airtel Private Limited, wherein the Delhi High Court held that the dispute between the telecom licensee and the infrastructure providers must go to TDSAT and not to be decided by the arbitral tribunal. This decision stems from the interpretation of the provisions of 2(1)(e) and J, which provide for the definitions of the licensee, service provider, respectively. Prima facie, it appears that TDSAT has broad exclusive powers to adjudicate certain types of disputes, including those arising between private parties, where arbitration cannot be resorted to. This hampers the spirit of party autonomy, which is integral to arbitration. With some exceptions, Indian courts and TDSAT itself have generally found telecom disputes to be non-arbitrable on the basis that establishment of special tribunals overrides the more general Arbitration Act. I read this judgment also. This therefore raises the questions on the arbitrability of telecom disputes in the light of the exclusive jurisdiction of several matters with TDSAT and consequently the diminishing rule of arbitration in this area. According to the mixed, is a section of Section 7B of the Indian Telegraph Act which provides for statutory arbitration. Under Section 7B, any dispute concerning a telegraph line, appliance or apparatus between the telegraph authority and the person for whose benefit the line, appliance or apparatus is or has been provided has to be determined by arbitration. Such dispute has to be referred to an arbitrator appointed by the central government, either especially for the determination of that dispute or generally for the determination of the disputes under the section. A recent judgment of the Supreme Court in Vodafone Idea Cellular Limited versus Ajay Kumar Agarwal discusses the ouster of jurisdiction under Section 7B of the Telegraph Act. In this case, the maintainability of the complaint filed before the District Consumer Redressal Forum came up before the court in the light of Section 7B of the Telegraph Act. That Section 7B housed the jurisdiction of the Consumer Forum. The court held existence of an arbitral remedy under Section 7B will not house the jurisdiction of the Consumer Forum, and that it is open to a consumer to opt for the remedy of arbitration, though there is no compulsion in law to do so. Therefore, it was open to a consumer to seek recourse to the remedies which are provided under the Consumer Protection Act 1986, now replaced by Act of 2019. The mediation bill is being discussed at length in different fora, and it is very likely that the mediation would become an act. It can thus be seen that the business community at large is interested in the alternative dispute resolutions. The telecom disputes should also be referred to arbitration by following party autonomy with necessary caution. It is not that every dispute is arbitrable. The fine distinction has to come by way of judicial pronouncements, and TDSAT would consider the proposition in appropriate cases and the march of law. Having said this, it is necessarily to be remembered that considering the progress that the tribunal has made and the number of cases that they have disposed of, if that is more viable, in my respectful submission, TDSAT should continue, because ultimately, if ultimate idea is that justice should be delivered speedily, whether it is by arbitration, mediation, or through proper adjudication by a tribunal. Thank you so much. Jai Hind, Vande Mataram.
Thank you so much, sir. We are honored to have you with us today. Our next guest, I'd like to introduce Shri P. Wilson, Senior Advocate and Honorable Member of Parliament. Senior Advocate Shri P. Wilson has served the legal fraternity as well as the country in his role as a Rajya Sabha member, member of Committee of Personal Public Grievances, Law and Justice member, Committee of Privileges member, Consultative Committee of Defense. He is also a coordinator for Niti Karangal, a pro bono program conceived by him and it was conducted in coordination with the Tamil Nadu Advocates Forum to help the poor litigants to effectively defend their cases before various courts. He has participated in debates with regard to bills and motions brought forward and has also had an active role in the special mention 0-hour questions, including debate on Arms Amendment Bill 2019, Surrogacy Regulation Bill 2019, to name a few. And indeed, they are a reflection of his wisdom and intellect. Sir, I would like to welcome you to please grace us with your presence.
Honorable Justice M.M. Sundaresh, Judge Supreme Court of India, Honorable Justice T. Raja, Acting Chief Justice, Madras High Court, Honorable Justice Anita Sumant, Honorable Justice Saravanan, Honorable Justice Abdul Qudus, Honorable Justice Dhirubhai Narayanbhai Patel, D.N. Patel, affectionately called D.N. Patel, Chairperson of TDSAT, Honorable TDSAT members, Justice Ram Krishna Gautam, Mr. Subodh Kumar Gupta, through S. Sankaranarayanan, Additional Solicitor General of India, through A.R.L. Sundaresan, Additional Solicitor General of India, through S. Prabhakaran, Vice Chairman, All India Bar Council, through S. Muthukumar, State Government Pleader, Madras High Court, the officials from ELCOT, Secretary Information Technology, senior advocates, other dignitaries who have come to attend this seminar, ladies